Well, let's get some more perspective on how everything is expected to play out. I need to remind you, of course, that no trial date has been set. It is just an appearance of Oscar Pistorius later this morning. But nonetheless, let's take you to a man who knows a lot more about this than I do. It's a regular guest on the show, criminal law expert, Mr. William Booth. He's in our Cape Town studio. Mr. Booth, good morning to you. As always, a huge pleasure to have you on the show. Is the expected postponement in a case of this magnitude fairly normal for a case like this?
Good morning. Yes, it is. In fact, murder matters take a long time before trial dates are set in the High Court. The state is obviously allowed a certain opportunity to complete their investigation, and that has to always be seen in light of an accused right in terms of our Constitution to have his trial dealt with as speedily as possible. So what will happen today is Mr. Pistorius will appear. I believe the prosecutor is going to ask for further indulgence to allow the police to complete the investigation. But this is normal, and in fact, investigation in complex cases can possibly take many months. But again, a court can't just continually postpone a matter to allow the state to investigate. It has to at some stage say, well, enough is enough, and they've had more than enough opportunity to complete investigation, and trial dates need to be set. So that must be seen in that kind of context.
And once this trial date has been set and everything is in full swing, the scheduling of the offence, Mr. Booth, if I could ask you to elaborate the difference between what the prosecution are determining and also what the defence are determining, a Schedule 6 versus a Schedule 5, my understanding. Can you explain to us what exactly the differences are?
Well, essentially the difference is with a Schedule 6 offence that it is premeditated or planned murder. The schedules are really very important at bail hearings because it places more of an onus on an accused person to convince the court that he or she should be released. When it comes to a trial, obviously it is very important as well for the state to try and prove premeditated murder, because the major differences relate to the sentences that can be imposed. In South Africa, we have certain minimum sentences, and if the state can prove beyond a reasonable doubt at a trial that an accused has planned a murder, a life sentence can possibly be imposed, but not in a situation where they can't establish planned or premeditated murder.
Why, if you could explain, the evidence put forward during the bail hearing, which we know did lead to Mr. Pistorius being released on bail, it cannot necessarily be used in the trial itself. Is my understanding of that correct? And perhaps you could elaborate on why that is the situation.
Well, bail proceedings are governed by the Criminal Procedure Act. And at a bail hearing, the presiding magistrate has to warn an accused person that the bail proceedings can in fact be used at a trial. The accused does not have to testify about the merits of the case. But if he does, and if he has been warned of that fact, then that evidence can later at the trial be used by the state in trying to prove its case. But an accused has a right to remain silent on the actual event. If he elects to testify about it or present evidence by way of an affidavit, that can be used against him later in court. But there is an obligation on the magistrate hearing the bail proceedings to warn him of that fact.
Just a final question to you, as briefly as you could, Mr. Booth, if you don't mind. Is there any chance at all that Mr. Pistorius could be taken into custody between now and a trial date being set, or all of that was put to bed during the bail hearing? Nothing from that hearing can be changed until a trial date has been set.
Well, the only time when he could be arrested again is if he's breached any of his bail conditions. And those are very specific. Some of them have been changed by the Pretoria High Court. So if there's an indication that he's not complying, and if he doesn't arrive at court, for example, then obviously a warrant of arrest will be issued, and then he can be arrested. But if he complies with all the conditions, well, then the situation pretty much remains the same right up to the trial, and in fact right through the trial.
Mr. Booth, as always, a huge pleasure to have you with us, making sense of what is expected in court today. My thanks to criminal law expert Mr. William Booth. By the way, we have ongoing coverage from our reporters, both Kathy Mokhaklana and Karen Moore. You can follow them on Twitter. You simply go and look for our Twitter handle. It is at eNCA News. You'll see all the activity there, and also, of course, on eNCA.com.
News that moves. eNCA.com.